Constitutional Court says men can now take women's surname. But what if South Africa wants to reverse this ruling? Okay, before I go to that, how this can be reversed, this ruling can be reversed, we need to explain to you what are the clan names, what are the difference between Indigenous South African culture and the European surname. So in South African Indigenous culture, clan names can either be surname or can be the same or can be separate, all right? But these are not transferable. Whether they are surname or clan names, they are not transferred through marriage the way European surnames are. They are not transferred through marriage the way European surnames are. So isiduko from the Xhosa or isibongo from Zulu, they comes from birth and lineage. They're not paperwork. All right, they're not a legal identity tick boxing. All right, marriage does not give you a clan name. You are welcome into a family, but your ancestral identity remains. So that's why, many Indigenous South African elders would say to someone when they get married, you marry into a family, but you don't lose who you are. So when courts treat surnames like interchangeable labels, they misunderstand the cultural differences. In the South African Indigenous cultural system, clan names is heritage, not marital contract. You cannot give somebody who you are your heritage. So, clan name is more like a DNA. It's your DNA. It's your oral DNA than a driver license. It's more likely a DNA than it's your driver's license. All right? So, clan names are not your driver's license, are not legal thing that identify who you are. They it's the link between people and their ancestors. The way families trace kinship to avoid marrying within the same bloodlines. The heart of cultural identity. It's also a living archive of history, migration, and belonging. So when South Africans, we say clan names, when we say in South Africa clan names are South Africans, we mean they embodies who we are, deeper than the borders, deeper than law. That's why this ruling is so problematic. This one, it's actually so woke. It's on steroids, if I may use that term. All right, the three ways this could be reversed. Anyway, the surname ruling is that first, we need a constitutional amendment. Like I said, Parliament with two-thirds majority can change the constitution to protect clan names and make sure customary law is respected. That's the first one. But also, I prefer they do that. They also take some power from these courts. They're a bit crazy. There's a lot of rulings they've done in the past that I think we need to remove this from them. We need to make sure that these staff it needs to consider the culture. They need to change that amendment. They need to consider South African culture and the historic context of South Africa above anything else when they make any judgment. So that is need to change that constitution, but we also need to actually have this one, all right, that protects the customary law in there as well. The second new legislation can be proposed, and that one will still be like treating these clan names as cultural heritage, indigenous surname or clan names as cultural heritage, as untouchable through marriage while still allowing choice for Western surnames. If people want to give their, like the husband wants to take a wife's surname, that's fine. That's your choice. But certain one has to be a no thing. Okay. The third thing is the fresh case. Now, there's already some word from the traditional leaders and cultural groups in South Africa. They're going to court to argue the ruling failed to honor certain sections, Section 30, 31, and 211 of the South African Constitution that protects culture and customary law. That ruling, I think they would win this one. They need to go back and actually trust this voter on this one. Another thing, yes, the court is final, but South Africans still have the power to defend our culture. The question is, do you think Parliament should step in? Comment below.